numbers than the first one.
I think we are live now.
Yeah, we are. Yeah. We are live, and perhaps we can start in about a minute or so. I think that'll be fine.
Just to say, I might have to nip out quickly if my doorbell rings, which I've arranged will not be while I'm doing my bit of the talk. So if I vanish from the screen momentarily, I will be coming back.
No worries. Oh, we'll ask Geraldine to sort of, fill in the gaps.
I'll pick a random slide at that point to talk about. So I'm going to turn my camera off when the other people are talking, just so there's less distractions. So
yeah, in the beginning, I think we can all be present till I finish everybody's introduction, and then I move to Murali. That's when I think Murali can take over, and I suppose things will be on autoplay from there on. I have a bit of trouble with my voice today. Not entirely sure why this is the case.
We might have to give it 5 minutes.
Yep. Okay, shall we begin in that case? Yeah, I think it's 6:35 p.m. India time. Great. So welcome to session 2 of this 6-part series on FIDIC conditions of contract. This is an initiative by SCL-India, which is in collaboration with Keating Chambers, driver Trett, and Jagannathan and company. And I want to thank especially our supporters for contributing and being part of this particular session. You will have to excuse my voice today. It's a bit cracky. It's not really the internet connection, so you don't have to like really refresh or anything. It's just my voice as it is today. And I will try my best to not sound like a scratch disc through the sessions. But you see, the series itself, and I want to sort of introduce about the series a bit. The series itself is quite timely and relevant for today, especially for India, given the landscape of the construction contracts as we should see today. More and more, in fact, more often than not, we are witnessing the use of FIDIC contracts, both in the private and both by private employers as well as government employers, and especially in the government sector. There is a wide use of FIDIC contracts, particularly where the development banks are involved. And it's been a phenomenon that at least I've seen quite recently, which has increased in the last few years. So FIDIC contracts as such has inserted itself into the Indian environment. And when I say environment, I mean both the legal and the practical environment. And now it's competing against forms which were developed locally by the employers here. And back in the day, I used to hear the phrase draconian contracts quite often. But FIDIC has now come into the picture, providing its fair balance between the contractor and the employer rights, at least perceived fairness between the employer and the contractor. And that's what we're dealing with today. We're dealing with a contract that's becoming quite popular even in the Indian scenario. Hence, it makes absolute sense for us for this event to have happened. And so far, we've been able to actually cover session 1, which was on the FIDIC suite, covering a wide range of contracts forms, especially the yellow, red, silver, and the pink books. And quite frankly, in my few years of practice, and I joined the bar in 2015, and since then I've seen quite a lot of FIDIC in operation, and including all the other forms that I just mentioned. And so far in session 1, we had the privilege of hearing Paul Batrick from driver Trett, Jenny Weil from Keating Chambers, Venkat Ramadurai from C-Cube Consultants, and Adriana Spasova from the FIDIC Contracts Committee. And all of them have already set a certain foundation for us, describing what the various FIDIC forms are. And this session 2 is something that will take it further from here. And today's session will deal with practical administration of FIDIC contracts. That's the theme for today. And our speakers have been able to narrow down the topics to 4 or 5 themes, which, for instance, Murali is going to start with, and I'm going to introduce all of you separately, but we'll begin with Dr. Murali, who will start on commencement, advance warning. I think this comes from the 2017, program requirement, delay events, and EOT applications. That's going to be the range of topics that Dr. Murali was going to cover. Moving from there, we will hear from Lucy, who will talk on change, as well as notice requirements under the FIDIC forms. And then lastly, we'll also hear from Geraldine, who will touch upon measurements, valuation, and engineer's determination thereof. So that's going to be the broad 3 or 4 topics that we'll hear from our speakers today. So let me start by introducing our panelists, actually, and I'll begin with Dr. Murali in the series in which they will speak. So Dr. Murali happens to be a faculty at the L&T Institute of Project Management. He specializes in contracts and claims management. Before he was in L&T, he was also in NICMAR, Pune. And that again is one of the most prestigious institutes for project management in India. The thing about Dr. Murali is that he's not just an academic, you see. He also brings tremendous amount of industry experience from his previous position in L&T as in the L&T's team for project or business development, right? And there, I think, I suppose your broad areas of work involve bidding for projects and planning and coordinating projects. And therefore, you are a good combination, I thought, of bringing the academics and the practice together. And for those who want to read more of his work, I think there are plenty of publications that you will find of Dr. Murali available online. And so I will encourage all our viewers to go check them out and see his work, the things that he's written. And so, Dr. Murali, thank you so much for joining the session.
Thanks, Gracious. Thank you very much.
Now we'll move to Lucy, who's a King's Counsel and a member of Keating Chambers. And I love one of the quotes that your client gave about you. It says, "An exceptionally good operator who wears her enormous intellect lightly." And I think that speaks volumes about the work that you've done as a specialist in construction law. What I could gather from your profile, that I think you love advocacy, right? This is something that I've understood that runs both in tribunals as well as in courts before the TCC and the commercial courts in the UK. And yet again, we have another academic before us in the sense that Lucy has made enormous contributions in writing as well. So I've seen your work in Keating on offshore contracts and marine engineering. In fact, I just bought that yesterday because I do have a case that involves the marine engineering. So I thought it would be a good reference, and perhaps I'm going to write a couple of emails to you asking a couple of questions too. Then she's written the litigation in the TCC, Keating on JCT contracts, and Keating's on construction contracts, which is one of the most recommended treatises on construction contracts. But what I found really more interesting, I should say, about Lucy was her trip to Sierra Leone, and that's something I found very interesting. And she's written a blog on it, and I went through a couple of those posts, and I really enjoyed reading it, by the way. So, so thanks a lot, Lucy, for joining us. We really appreciate your presence in the panel.
Thank you.
From here, we'll move to Geraldine. And Geraldine is an operations director at Trett. And Trett, as we mentioned, is one of the specialists in dispute avoidance and dispute resolution. And so you bring that experience to us in this panel, because it's not just enough to just discuss what the provisions say, but we also have to sort of talk about the kind of dispute avoidance that one needs to do and dispute resolution parts of it as well. Now, Geraldine comes with a deadly combination of being a QS and having a law degree. So that's great. And that's probably why I've seen that your work involves a lot of engagements for preparing, defending, negotiating claims. And that's in a wide range of projects involving, various industries. So not surprising that she has several publications to her name as well. And I would again encourage our viewers to go and look out for all these publications by our panelists. So once again, thank you to all the three of you for being here. I know this is a very long and intensive 2.5 hours. And so we appreciate that you've given your time for this session. So with that, I think we can shift to Dr. Murali to start with his presentation. And from there on, we'll move to Lucy. And the structure of this session is going to be that with the first two speakers done, we will take a 5 to 10 minute break. And then we will move to Geraldine's presentation. And for the viewers who are watching, I would encourage that you may, if you have any questions, you can feel free to drop it on the comments section or on the live chat that's actually next to on the viewing platform on YouTube. So with that, Dr. Murali, I think I think you can take over the session. We'd love to hear from you.
I'll do that. Let me just share my screen.
Sure.
So is my screen visible?
Yes, sir.
Right. Thanks. So thank you, Gracious, for that introduction and for this opportunity to present here. So before I start, let me just tell you that whatever I'm going to present today is based out of my experience in dealing with a couple of contracts that was based on FIDIC, one on Red Book and one based on FIDIC Yellow Book in my earlier projects, and also based on my reading of certain very seminal books on FIDIC contracts, which I'll definitely share the references of those in the end of my presentation. And also I have referred to the FIDIC contracts guide a couple of times whenever I had any questions on interpretation or whenever during any discussions with my employer in any of the discussions on the claims negotiation. So I keep referring to this FIDIC contract guide, and that's how I developed interest in this particular contract form. So today, as Gracious said, we are going to, in the next 30 minutes from my side, we are going to talk about some of the clauses and sub-clauses, essentially clause number 8 and sub-clauses under clause number 8 that deals with time-related provisions. That's commencement, completion, program, EOT, rate of progress, and delays. So when we take any construction project, the first thing that bothers once the contract is awarded is when does the official start of the project occur? That is when does the countdown begin? So we have a duration. So when does it start? So that's where the project commencement comes into picture, and this is elaborately dealt in clause number 8.1 of FIDIC contracts. Since we are only talking about 1999 contracts and the 3 books, that is the red, silver, and yellow. These are the 3 books that I'm going to refer in my presentation. So whenever we talk about commencement or the date of commencement, we actually refer to some kind of a reference point, right? So say, for example, I should say that a project commences, the commencement date of the project is 10 days from, say, the letter of acceptance, or 10 days from the contract signing. So there is some kind of a reference which we take to define the commencement date of the project. And in FIDIC contracts, at least in Silver Book, this reference point would be the date on which the contract becomes effective, which is the date that is indicated in the contract agreement that is signed between the parties. But if it is Red and Yellow Book, it is the letter of acceptance is the reference point that is very often referred in different parts of the contract. But that doesn't mean that letter of acceptance is the date of letter of acceptance is the date on which the contract becomes effective. Typically, in Red and Yellow Books, contract becomes effective when the employer accepts the letter of tender. But nevertheless, what we refer very frequently, what we see very frequently in FIDIC Red and Yellow Book would be your letter of acceptance date. So therefore, let's take that as the key reference point. From this key reference point, whether it is contract signing or the letter of acceptance, within 42 days, there should be the commencement date. Commencement date should occur. So that is the employer, if the employer wishes to, the commencement date must be within 42 days from the reference point. Now, this gives a kind of certainty to the contractor that it would happen within these 42 days. That's one good aspect of FIDIC, because many times I've seen that after the letter of acceptance, it takes a lot of time for the employer to actually come up with the commencement date. So this clarifies a lot of questions that would have on when is my commencement date. Now, but this is not sufficient, because within this 42-day window, one fine day, your employer can come and tell you as a contractor, that tomorrow morning is going to be the commencement day. So that is something, it's going to be a surprise, which would make the contractor's life difficult in the site. So FIDIC comes up with the concept of notice of commencement date. So when the employer wishes, suppose say the employer wants the commencement date to be X, the notice of commencement must be at least 7 days before this intended commencement date. So if X is the commencement date which the employer wants, X minus 7 should be the date on which the notice of commencement should be sent from the employer's side or from the engineer representing the employer. So this should be at least 7 days. So this gives enough time for the contractor to prepare for commencing the project once once the date occurs. Now, the moment we say commencement date, at least in most of the Indian contracts, we take it for granted that on this particular commencement day, the access to site would be available with the contractor. That is, the employer has actually enabled the access to the site to the contractor. But in FIDIC, there is this clause 2.1 that actually talks about the access to the site and the date on which this access to the site would be given to the contractor. Typically, this date would be mentioned in the appendix to tender in case of FIDIC red and yellow book, or it would be in the particular conditions of contract in case of FIDIC silver book. Now, it might so happen that the commencement date and the access to site, the date for access to site might be different. And this would create a lot of confusion, because on the commencement day, it is the expectation of the contractor that the site would be available. But if that is not the case, then it might lead to certain confusion. So employees should, to the extent possible, should ensure that before they announce the commencement date, the access to the site and all the required permits from the employer side should be obtained, and it should be clear, and so that by the commencement date, the access would be possible. Now, this is not the only point, and the contractors also should keep in mind that submission of performance security as per clause number 4.2 is a prerequisite for access to site. So typically what happens is clause number 4.2 gives 28 days for the contractor from the letter of acceptance in case of red and yellow, or contract signing in case of silver book, for submission of performance security. 28 days window is available. But if it's not prudent to wait for these 28 days, because especially when access to site is tied with the performance security. So it is important that this performance security is submitted and access to the site is, you become eligible for the access to the site as a contractor, and employer takes care that the access to the site is practically possible before the announcement of the commencement date. So this is something that we need to keep in mind when it comes to the clause number 8.1. So otherwise, the clause is pretty clear. Only thing we need to be careful about these dates: commencement date, access to their site date, and getting the performance security and submitting it within time. The next subclause talks about the completion time or the project duration. Now we have seen this up to the commencement date, and the completion time is the time required for taking over of time required for the client. That is the date on which the client would be issuing the certificate of taking over of sections and works. Right, so that would be the completion time for the contractor. Now, when I say completion time, it's typically defined in days. And if you look at the definitions clause, the day is a calendar day. Okay, so therefore, if it's 200 calendar days, so it is the completion time is 200 days. It's 200 calendar days. So from commencement date, it is 200 days. Within 200 days, you will have to ensure that you receive the certificate of taking over of sections and works by the employer. So now, a word of caution here. FIDIC uses the term sections and works. Now, these sections are slightly different from what we typically see in India. Now, in India, we are very used to this concept of milestones. Milestone, the client defines certain milestones. Suppose, say, there is a 10-floor building. The client defines that every 2 floors is a milestone. Say, for example, every 2nd floor is a milestone. But this section that FIDIC defines is slightly different from this kind of a in-progress milestone. Sections in FIDIC refer to a complete part of the entire work that would be handed over within the time that is defined for the taking over of the section to the employer. Now, it's to put it in very simple terms, a section is a project, is a kind of a mini project within a project, right? So all the importance that we attach to the completion of the work as a whole is something that we need to attach to the section as well. That is something that we need to keep in mind. And clause number 10.1 talks about, it defines more about what exactly the certificate of taking over means and what are the prerequisites that to be met for the employer to issue the certificate of taking over. Because just how the commencement date is so important, even the taking over date is also very important, because this has to happen within this completion time that's defined in the clause number 8.2. Now, in case the employer wants to keep out certain things out of this certificate for taking over, so that can be done provided it is defined accordingly under 10.1 in the contract, right? Then comes the subclause 8.3 that talks about the program or the project schedule, and this needs to be submitted from within 28 days from the commencement. And we have just now seen what exactly is commencement. Now, the contract calls for in case of red and yellow, the contract forms called the general conditions. It calls for a detailed program. Now, what exactly is a detailed program is something that's not very clear, but the conditions of contract attempt to explain what exactly is expected out of this particular schedule. Like, for example, in case of red and yellow, what is expected out of the schedule is the timing for every stage of the work. Now, in case of red, you may not have design, but of course, there can be some little bit portion of design if the employer intends to. But predominantly, in case of yellow, you have the design as a key stage, then procurement, construction, etc. So this is what the employer is looking for. And within this, what is the level of detail is something that needs to be worked out with the between the client and the contractor. But in case of silver, and by now you would be knowing the definition of a silver contract and what condition silver book is used. And here the timing of each major stage is what it has been defined. So it's less in the sense in red and yellow, the client is very particular about what they want, but in silver they define it as a major stage of work. One interesting thing that I found in the program requirements of FIDIC contract is that there's no specific mention of identification of a critical path or the specific tools that needs to be used for analysis of schedule or creating the schedule. Like for example, in our central PWD works contracts, it clearly says that that the parties have to agree on a particular software, whether it is Microsoft Project or whether it is Oracle Primavera. So it has to be agreed between the parties, but there's no specific mention of such kind of tools, at least in the general conditions of contract of FIDIC books. Now then comes the question, if contractor is expected to submit this within 28 days from the commencement, what is expected from the employer side? Is it that the employer should approve it or something like that? As such, there is no approval requirements. The 21 days is the time given to the engineer to come back if they have any comments on that particular schedule, and if not, then it means that it is that the contractor continues with the schedule if there are no comments. So as such, what I'm trying to say is that there is no requirement for any approval from the employer side, and that's how it is in FIDIC contract. Now, a very interesting concept, though they don't call it as advance or early warning in the 1999 version, but at least in the 2017, they clearly call it as an advance warning clause. Similar to that, though they are not the same, but it's at least to a great extent, at least the intent is similar in case of 8.3. You have this advance warning clause wherein it is expected that the contractor warns the employer of certain specific probable events which might have an adverse impact on the project time or cost. So this kind of warning is expected from the contractor whenever the contractor finds such kind of an event or such kind of an issue is probably looming. Some more details about this advance warning, because I had a couple of problems when I was in a project with respect to this advance warning and notice of advance warning, and there were some discussions on that, so I just wanted to share that with you. Now the question comes as, what if this advance warning is not given? So the under 8.3, it is required for the contractor to give this advance warning. But what if the advance warning is not given? Now, advance warning or this under this 8.3 subclause of 8.3, if this notice of specific probable future events that can have an adverse impact on the project time and cost, if this warning is not given by the contractor, then in my opinion, it might amount to the kind of a breach of contractual obligations, and it might even attract 15.2, depending upon the seriousness of that particular issue that we are discussing about. But nevertheless, it is a kind of obligation that is thrusted on the contractor to come up with kind of warning. Now, engineer may also take this into account when they are determining a particular claim or a particular issue or a particular variation when they're dealing with that, and they take into account whether the contractor has given an advance warning or not for this particular thing that they are trying to determine. So that is the contract has this clause under for this engineer. You might see under clause number 3, if I'm right, that says about with due regard to all circumstances. So this can also be one of the circumstances which the engineer might consider while evaluating the claims submitted by the contractor. That is whether advance warning was given or not given. Now, there is another school of thought, kind of a counter view to this, that says that if advance warning is not given, it would not amount to a breach of contract. Now, let me give you a situation to just illustrate this particular scenario. Say, for example, there is a situation where there can be a probable future event that can cause an adverse effect on project cost or time or both, and the contractor has not given this advance warning. Let's say that they have not given the advance warning. And let's again say that that particular event actually becomes true. that event happens, actually, that is going to cause an adverse impact on the cost and time of the contract. In such a case, say this contractor submits a notice to claim under 20.1 to the employer to recover the costs, impact of costs that is going to additional cost that they're going to incur because of this particular event. Now, the employer rejects it, saying that you have not given any advance warning, so therefore I'm not going to this particular claim is rejected. Now, if the employer does this, the employer is risking by considering this failure to submit the advance warning notice as a failure to failure to issue a notice to claim, something like that. So this advance warning, they are treating it equal to something like a notice to claim. And if it's treated as equivalent to as a prerequisite for as a notice to claim, then a claim is actually a discretion for the contractor. So it's not an obligation that they have to submit a claim. It's a discretion. Notice to claim is a discretion. If they don't submit, the claim is not processed, as simple as that. And if they submit within time, subject to the conditions of the contract, they have their claim that is being reviewed by the engineer. Now, if they don't submit it, then it's not something wrong. That's the meaning that comes. So therefore, some people say that not submitting this advance warning notice is okay. It's not a problem. But if you look at the language under 8.3, it's quite clear that the employer intends this particular notice as an obligation. And in my opinion, this is something that should not be confused with the notice under 20.1. So these are probably two separate things that we need to take into account. This is more of an obligation, but the notice under 20.1 is more of a discretion. So the contractor, if they don't submit this notice, subject to other clauses of the contract, then it's okay. But here, this particular notice is something that's important. By when should this warning be given? And as per the contract, it says that it should be given promptly. And the word promptly, in my opinion, means without any delay. That's as simple as that. Then who should give the warning? In case of 1999 books, it is the contractor who's supposed to give the warning. But in 2017, it is both the parties. So that is something that's changed in the 2017 version. Though in most of the cases, employer would also actually warn the contractor in case of such kind of adverse events. But in 2017, it has been made the obligation of both parties. Rather in 1919, it is the obligation is thrusted on the contractor. Next comes this extension of time clause. Now, this clause contains a list of circumstances under which an extension of time would be granted to the contractor. Now, we all know that in a contract where time is considered to be of essence, extension of time clause is very, very crucial to prevent the contract from becoming from the time becoming time at large. So then the employer would lose the right to recover damages. So to avoid these complications, extension of time clause is a very, very crucial or important clause in any contract, especially when time is of essence. And when I say time is of essence, in India, you might be aware that the courts have repeatedly said time is of essence when there is an explicit provision in the contract that time is of essence. Now, if you look at this list of events that can entitle a contractor for an extension of time, what caught my eye was the out of the 5 listed events there in the red and yellow book, the last 2, which I could relate it with kind of COVID claims. Now, in case the contractor finds that sourcing resources or workers is difficult because of, say, COVID-related issues or because of COVID and its impact, then 8.4, I think D is one clause that can come to the rescue of the contractor for seeking an extension of time. And I appreciate the kind of thinking that has gone into the 1999 version of the FIDIC contract, or in general the FIDIC contracts, that even in 1999 contract form can be successfully used for COVID-related claims, at least for the extension of time to the that has happened today after 20 years after that particular form was actually drafted. Now, 8.4E is a provision which the contractor can use in case there is a kind of delays or impediment or kind of prevention by the employer in completing their obligations or providing approvals. Typically, I was looking at one of the recent releases of FIDIC contracts, wherein they say that if the employer is or the engineer is say working remotely, okay, so and that is causing an impact on the decision making at site, and thus that has an impact on the taking over of projects, that is impact on the completion of the work or taking over by the client under 10.1, then it can be parked under this particular extension of time request can be made under 8.4 E. That is the fifth bullet point under 8.4 clause number, subclause. Now, one very important thing that we need to keep in mind, at least for those who are not used to FIDIC contracts in India, is that there can be sectional LDs, liquidated damages. So therefore, whenever the sectional deadlines or the sectional milestones, I told you what is a section. It's an independent, it's a kind of a project within a mini project within a project. If there are any events that qualifies under 8.4, that is actually causing an impact on the sectional completion, then it is important that you seek an extension of time. You cannot keep quiet thinking that anyways section is a part of the work and let the entire work, if the entire work is affected, I need to worry about extension of time. It's not like that. You need to worry about extension of time for every section as though they are the extension of time for the entire work. So that is very important when it comes to FIDIC contracts. Now, another interesting aspect in FIDIC contract is exceptionally adverse climatic condition is one of the event that can qualify for extension of time under 8.4. And interestingly, the moment I say adverse climatic condition, the next question I'm sure that would come to your mind is what exactly is adverse, right? What could be the condition that could be defined as an adverse condition, or how to prove it? Now, this is where I find FIDIC contract guide a very interesting document to understand FIDIC contracts and the thought process behind it. So in FIDIC contract guide, it is defined as the exceptionally adverse climatic condition can be defined as the probability of a particular event, okay, that say for example that particular event should occur once in say 4 to 5 times of the project duration. Like say for example the project duration is 3 years. If that particular climatic condition occurs in say 12 or 15 years once, then it is said to be an exceptionally adverse climatic condition. So that is some kind of metric that they have provided to define what is adverse. So that's under such scenarios you can seek an extension of time if it is impacting either your sectional milestones or your overall the taking over of the work or taking over of the section, whatever it is. Now the next question would be, would I get an additional payment? The answer is no, but in case the adverse climatic conditions have an impact in terms of or damage to property or damage to some kind of temporary structures or permanent works, then probably section 17 is clause 17 is something that you can look for. But even then, if you have insurance and there's some other complications that might occur, so typically these might be covered under insurance as well. So additional payment, I'm not sure, I don't think there is much of a scope for this under exceptionally adverse climatic conditions. Now, one interesting thing in FIDIC contract, which many times is a problem in our Indian contracts, is that when it comes to determination, with every determination, the total time extension may increase, but it will not decrease. So that is one interesting explicit statement that is made. And when I was going through some of the seminal books on FIDIC contracts, and some of the authors have even expressed that even if there are a number of descoping related variations, okay, so that would not amount to reduction in the total time extension in case it qualifies for that. So this is one particular provision that's quite important and I think makes it quite fair. Now then comes the question whether FIDIC contracts support disruption claim. In my opinion, there is no explicit statement on this particular aspect in FIDIC contract. But yes, it is. You need to keep in mind that again, the sectional completion is something that is important. As a contractor, I cannot keep quiet in case a particular delay event under section 8.4 under subclause 8.4 is having an impact on the sectional takeover, but not on the overall work takeover. I cannot keep quiet. I will have to seek an extension of time. Otherwise, I would be liable for liquidated damages. So that is something that you need to keep in your mind. Then 8.5 talks about delays by authorities, and slightly different in Silver Book. You can look at the text. Now, delays by authorities is one such clause which the recent guideline of FIDIC COVID-related guidelines, which they have recommended that 8.5 is one particular subclause that can be used in case, say, for example, your projects have need some kind of inspection by authorities. Okay, because post-COVID guidelines, are they being followed or not? If the authorities want to inspect that, then that particular inspection, if it causes any impact on the sectional taking over or the overall work takeover, then that can be claimed under the extension of time can be put up under 8.5. And again, the question is, and it is silent about the financial consequences. Maybe it is something that depends on particular circumstances. So the contract is not saying anything about financial consequences, the general conditions of contract. Now, the next clause is on the section subclause 8.6 that talks about the rate of progress. Now, in case the project is affected by some of the events, which is other than 8.4, that is under the events that are eligible for an extension of time, which is mostly the events which are attributable to the contractor, then the engineer has the power or the authority, or the employer in case of Silver Book, to submit a revised schedule and also to make good for the delays that is occurring, so that the contractor completes the project within the time for completion, or the time for completion plus extension of time, approved extension of time that has been awarded to the contractor. Now, suppose, let's say that a project is delayed because of reasons other than 8.4, and the employer instructs the contractor to make sure that the rate of progress is improved, so that the project gets completed within the time for completion and the approved extension of time. And say the contractor employs additional resources to do this, or the contractor gets into kind of night shift as well. This would require the employer to put additional resources to supervise it. And that is some cost, and the employer is going to incur some costs as a result of this. And this is something that the employer can recover under employer's claim, which is discussed in clause number 2.5. So that is separately on employer's claims. Employer also can put up a claim, just like how a contractor puts up a claim. Now, this particular clause of rate of progress becomes inapplicable if time is at large. That is when the contractors it's due, extension of time is due for the contractor, and if the engineer or the employer is not processing that extension of time as per the requirements of the contract, then you cannot expect the contractor to increase the rate of progress, because they are actually due for extension of time and you are not awarded, and now time is at large. Now, this particular clause on rate of progress should not be confused with the instruction to accelerate. Now, as far as what I have seen in Red Book, Yellow Book, Red Book and Yellow Book, Silver I will discuss it separately. Red and Yellow is that the engineer doesn't have an explicit right to instruct to accelerate. Now, when I say accelerate here, I mean accelerating a project such that it is completed before the time for completion or extension of time, time for completion, or in cases where extension of time is awarded, time for completion includes the extension of time also. That's per the definition of time for completion. So if the employer or the engineer wants the contractor to complete the project, or if they are intending to take over the works under 10.1 before the time for completion, then I would call it as an acceleration. That's typically acceleration. Now, such an explicit right of the employer or the engineer is not specifically seen anywhere in the Red and Yellow Book, at least in the general conditions of contract. But in case the engineer or the employer instructs, it has to be taken care of through the variation route under clause number 3. But in case of Silver Book, quite interestingly, the engineer's power to instruct variation is limited within the that is limited to the contractor fulfilling the obligations of the contract, which means that the contractor, the engineer doesn't have any authority to ask the contractor to accelerate the work. As per at least it says that whatever instruction that engineer gives is to ensure that the contractor completes as per their obligation, and completing earlier is not a contractor's obligation. So therefore, engineer cannot give an instruction to complete it earlier than time for completion, is what I could understand from the Silver Book. Now, under value engineering, a contractor can submit their own proposal. to accelerate the work. That is possible in either all the three books. It is possible for the contractor to come up with their proposal, but engineer as such cannot impose the requirement of acceleration onto the contractor. But what is one good thing that can happen is both the parties can mutually agree to accelerate. But one word of caution when you agree to accelerate mutually is you need to be very clear about what is going to happen if you don't complete the work within the accelerated deadline. So is the contractor liable for liquidated damages, or is the contractor liable for liquidated damages only if the contractor does not complete it as per the original time for completion as per the contract before acceleration? So this is something that the parties have to be clear, otherwise it would lead to unnecessary complication on a later date. Now the last subclause that I would discuss here is that damages for delay. This is something like our liquidated damage clause that we typically find in Indian contracts. A reasonable estimate of actual losses is what is defined in the percentages that is typically a part of appendix to tender or particular conditions of contract. We all know that at least in India, liquidated damages is a very hotly debated concept, at least in the courts. The thing is that even though there is a clause, is a liquidated damage clause, as per the views of the court, it is seen that the contractors have to prove what are their losses. So though you have a liquidated damage clause in the contract, that is because they have to be reasonable to make sure that it is reasonable. Now, in the event of opening up of this LD clause, typically this percentage that is defined in the contract comprises of the financing charges, supervision costs in the prolongation period, and the foregone benefits of the employer. This is something that I could understand from the FIDIC contract guide. And in the case of delayed completion, the employer gets nothing beyond these delay damages. Okay, so though there are specific clauses on say liabilities and limitation of liability, with respect to delayed completion, this is what the employer would get, whatever the percentages or the pro rata basis that is mentioned with an upper cap in the appendix to tender, or in case of red and silver, or the particular conditions of contract. Sorry, appendix to tender in case of red and yellow, and particular conditions of contract in case of silver book. Now, then this question comes many times, is that are delay damages waived off in case of culpable actions from the employer? Say, for example, the project is delayed for reasons other than clause number 8.4, and the contractor is now liable to pay liquidated damages. And now in this duration, when the contractor is liable to pay liquidated damages, the employer comes up with an instruction for variation. So would that, nullify the delay damages effect on the contractor? In my opinion, looking at the clauses of the contract, general conditions of contract, or the provisions of 8.7, no. In the sense, employer, even if they issue a variation in the period where the contractor is subjected to delay damages, that may not cause an impact that may not cause any change. The contractor still has to pay delay damages. So that is what I'm trying to say. What I could understand by reading a couple of books, what is the logic behind this? In fact, there was one very famous case that some of the books refer to, this Balfour case. And also, what I understand is that once a contractor is subjected to delay damages, it's the question of time at large doesn't exist, right? So in such a case, they are still, even in case of employer's culpable action, they have to pay the the damages that is supposed to be paid by the contractor. So employer's action, culpable actions, cannot waive off delay damages is something that I'm trying to see. So these are some of the key references that I have referred to firm up my understanding of this particular clauses of time-related clauses of FIDIC contract, and I would recommend all of you to have a look at these interesting publications on FIDIC contracts. And thank you very much, and we can take up some questions later whenever gracious permits. Thank you.
Great. Thanks a lot, Murali, for that. I have actually a lot of questions for you coming on the chat, but what I'm going to do is I'm going to try and consolidate them and synthesize them for you in the open forum time. And I would, again, encourage everybody who's viewing to just drop their questions on the chat. Even as Lucy presents gives her presentation, I will be able to sort of jot them down and be able to put forward to the panel of speakers. Lucy, the stage is yours.
Thank you very much. I'll just share my my screen.
It's
right.
visible.
Yep, great.
Great.
So I'm going to cover 4 topics, all of them on the sort of theme of managing change under FIDIC. First is the requirements for instructions, if there's going to be a change. Second one is whether the contractor has to do what he's told and the circumstances when he doesn't. The third is notice, which is often a very tricky area for the contractor. And the fourth is a point on discretion that you may see coming up, not under the FIDIC standard form, but often an amendment. So first is requirements for instruction. So I have pulled out the clauses under the 99 Red Book and the 2017 Red Book. And these clauses are reflected in the rest of the FIDIC suite with small differences. So I've used the Red Book as basically the starting point for the regime for managing change, and you'll find that in the other FIDIC books it's very, very similar. So under the 99 form, one starts off by a clause that says that the engineer can give the contractor instructions which are necessary for the execution of the works and the remedying of any defect. So a very wide power on the engineer to issue instructions. And you'll see that in the 2017 version of the Red Book, the instructions which can be issued are only those necessary for the execution of the works, but there's a separate bit in FIDIC 2017 dealing with rectification of defects. It's just not dealt with in a rolled up way like it is here. And the contractor can only take instructions from the engineer or from an appropriately authorised assistant. So it's quite important for the contractor to check who he's being told to do things by, because sometimes the employer can have people like a clerk of works that tell you to do things, but actually they haven't got any power to give you an instruction. And if you comply with it, then you wouldn't necessarily be entitled to any additional time or money. Both contracts, well, both versions of the Red Book want instructions to be given in writing. And obviously that has a practical advantage in that everybody knows where they are if the instructions come in writing. In reality, on a site, as I'm sure everyone listening to this knows, the instructions often are not in writing. They arise out of site discussions or meetings. And the 99 Red Book foresees that this might happen and provides for quite a tight timescale of notices and confirmations to be given, whereby the contractor who gets a written instruction can turn it into gets an oral instruction, can turn it into a written instruction by writing to say that was an instruction, by the way. Now, again, in my experience, these kinds of things are obeyed more in the breach than they are in the reality. So you usually find that there are issues where somebody gave an oral instruction and either the timescales for confirmation are not complied with, or nobody formally recorded it. And in those circumstances, what the contractor usually needs to do is to look for references to the particular issue in things like meeting minutes or even monthly reports, if that's the best source. Obviously, nowadays, lots of things are done by email. You should watch out for whether the contract has a bespoke provision in it, which provides that email doesn't count as a notice in writing, because sometimes they do. So there can be other requirements for instructions. In some contracts, there are bespoke changes requiring the instruction to come from a specific person. Could be the engineer, like in FIDIC, could be somebody else. Or you might need things like a signature, etc. Effectively, employers put these kinds of bespoke requirements in to try and make it more strict as to who's getting the instruction and who is not. What happens if the employer refuses to comply with a requirement like that, either because it doesn't consider the instruction to represent a change, or because it doesn't think that the matter requires an instruction? So there's obviously a very common situation on site where the contractor thinks that he's been told to do something which is a change to the works, and the employer thinks that actually it's within the original contract and there's a dispute about it. And if the contract makes the relevant proviso a condition precedent, then there are 2 English law cases that I've put in, recognising that these won't be directly applicable to Indian law, but may be useful to people who are trying to run these kinds of arguments as influencing the situation under Indian law. There's a Court of Appeal case, 2 Court of Appeal cases where it was a requirement that the various milestone that gave rise to money or change was signed by the employer, and the employer wouldn't do it. In Brodie, it was an engineer, like under FIDIC, and the courts don't like the idea that the employer, by failing to comply with a strict requirement like that, can effectively, through his own breach, create a situation where the contractor can't recover money for a change. And so there's been various two different ways of finding that, in fact, the employer is to be treated as if the requirement was complied with. Obliged to comply with instructions. Again, these are the clauses from the 2 different versions of the Red Book. And the starting point, of course, is that the contractor has to comply with the instructions, whether he thinks they're a change to the works or not. And I do sometimes get asked to advise contractors who are being asked to do something expensive or time-consuming as to what remedies they have under the contract for that problem in circumstances where the employer isn't accepting that the particular instruction gives rise to a change. And the answer is he doesn't have much of a remedy. In the 99 Red Book, there's only one exception, and that is that the contractor has to give notice saying that he can't readily obtain the goods required. So it's a materials issue. If you just can't supply the materials needed to carry out the varied works, then there's at least the contract recognises that the contractor can give an option saying, I can't do it. But you'll notice that the engineers can cancel, confirm, or vary the instruction. So the contractor could object and the engineer could say, you've got to do it anyway. Now, if the employer's wrong, if that's an employer change, then it may well be that the employer ends up paying over and above for that. But that's not much comfort to the contractor that has to bear that cost on an interim basis while the works are being carried out pending the resolution of the dispute. Under the 2017 version of FIDIC, the contractor has a few more ways of resisting an instruction. If the contractor considers it represents a variation or change to the works. So you've then got doesn't comply with the applicable laws, or will reduce the safety of the works, or is technically impossible, and then the contractor has to give a notice. So that's a little bit broader, although things are not often technically impossible. It may be better, a more fruitful line of argument might be reducing the safety of the works. It's also not often that employers give instructions that are actually illegal. So the range of circumstances in which the contractor can refuse to carry out an instruction are quite limited. And essentially the best thing to do if you're the contractor in this situation is get on with it and put your claims in to the employer as soon as possible. And on the topic of claims, you'll want to think about what the notice requirements under the contract are. And it is absolutely critical to a contractor successfully operating the administration of a construction contract that the contractor knows what the notice requirements are and is ready to comply with them whenever anything goes wrong that he thinks might entitle him to time or money. So the principles were set out, and again, I'm going to use English law cases because there's quite a developed jurisprudence in English law looking at different kinds of clauses and setting out what the principles are to try and work out whether the obligation in the clause you're looking at is something that if you don't comply with it will simply stop you completely from making any claim, or whether it's actually just an administrative requirement and in fact doesn't have any money or time consequences. That obviously being an absolutely critical distinction for both contractor and employer when they're looking at a dispute arising on the project. So the first case is Bramer back in 1978, and this was a case where there was a clause saying if there's a prohibition of export, blockade, or hostilities preventing fulfilment of the contract, then the unfilled proportion of the contract will be cancelled. And then it says, in the event of shipment proving impossible by reason of any of the causes listed in the contract, then the sellers have to advise buyers without delay of the reasons and then produce proof. And Bramer had to look at whether the highlighted words were a condition precedent to the cancellation, and therefore that the person saying they couldn't comply needed to have given the notification, the advice required before the contract could be cancelled. And the court said, you just look at the form of the clause itself. Unsurprisingly, it's just a clause in a contract, so that's what you're going to do. You're going to read it. The relationship of the clause to the rest of the contract, again, the usual rules for construing contracts and the general background of the law. And they say this one's not a condition precedent because the cancellation described in the first sentence is not expressed to be conditional upon compliance with the second sentence. So you simply don't get any words in that clause that say that the contract will only be cancelled if the advice has been given to the buyers. And they also comment that if a condition were intended, there'll probably be a definite time limit for the notice or advice to be given. And they contrasted the clause with other clauses in the contract, which said that which did have stricter language in. So the parties in that contract had chosen to make certain clauses conditions precedent, but they hadn't used that same language in this clause, which therefore the court assumes is a conscious choice. There's a case called Multiplex and Honeywell in the UK, which actually arose out of the Wembley Stadium construction. And this is useful because it tells you what the commercial purpose of notice provisions are. Contractors quite often argue that it's simply admin, it makes no difference, everybody knows what's going on. And in this case, Mr. Justice Jackson, as he then said, no, actually, contractual terms which require a contractor to give prompt notice serve a valuable purpose because you can investigate the issues arising in relation to the alleged change while they're still current. And sometimes the employer has the opportunity to withdraw instructions if a notice is given saying, we think what you've told us to do is going to cost a lot of money. The employer can then change his mind. FIDIC clause 20 is the clause that deals with what's usually referred to as claims control in FIDIC. And the claims control clauses in the FIDIC contracts could use up a 2.5-hour session all by themselves. So I'm just going to focus on the notice elements of them. So there's quite a detailed regime in the 99 version of FIDIC, and an even more detailed and onerous regime in the 2017 version. And in this slide, I've only given the first parts of the notice requirements because those are the ones that are usually regarded as having condition precedents in them. There is an ongoing further series of obligations in both forms for the contractor to provide further details. And in the 2017 form, in particular, the provision of further details such as particulars of delay and so on is also stated to be on the face of the form a condition precedent. So the 2017 form puts very, very onerous obligations, in fact, on both parties, but in practical terms, it will be the contractor that is needing to give notices because it's the contractor that will be wanting to make claims for additional time or money. So under clause 20.1 in the 99 form, if the contractor thinks he's due any extra time or money, then he has to give notice to the engineer describing the event or circumstance giving rise to the claim, and the notice has to be given as soon as practicable and not later than 28 days after the contractor became aware or should have become aware of the event or circumstance. And you'll notice straight away that in this clause there's a 28-day time limit, which consistently with the Bramer case is part of the express condition precedent nature of this clause. And we know that it's a condition precedent because the second part of clause 20.1 spells out in absolutely clear terms that if you don't give the notice, you won't get any extension of time, you won't get any additional money, and the employer is discharged from all liability in connection with the claim. And basically the same regime for the initial notice of claim applies in the 2017 version of FIDIC to both parties, because it's possible under the 2017 version of FIDIC that the employer might be saying that the contract price should be reduced. So those are the words of the clauses, and that's the regime that the contractor needs to be aware of. There's a few cases that are relevant to these clauses. And I've picked them up again. It's UK cases, but it's useful to know about them because of the different kinds of notice provision that you see in these clauses. And they sometimes people amend the notice provisions in FIDIC or in the contract you're looking at. And it's useful, I think, to know, okay, is there a similar version that's been looked at by the courts in another context, see what the courts have said about the way that particular clause is construed. So I've pulled out a few of the clauses that have been discussed in the main cases under English law. So the first one is in Stereo and Sigma, and the clause has refers to where the contractor claiming extension of time, and says that if there is a claim, then in any such case, provided the subcontractor shall have given written notice, then you'll get an extension of time. Doesn't say if you don't, it doesn't expressly say if you don't give notice, you won't get the time, but it does have the word provided in the clause. And the court said, okay, if there's genuine ambiguity as to whether the notification is a condition precedent under the contract, then you shouldn't construe it that way, because the provision operates for the benefit of only one party and deprives the contractor of very significant rights which he would otherwise enjoy. But this clause was found to be a condition precedent because the phrase provided that was sufficiently clear, and you didn't need the express warning as to the consequences of non-compliance if the proviso wording was clear enough in ordinary language. So that's one to be aware of. In FIDIC, of course, there is an express warning, so you won't normally have the opportunity of even arguing this point, but worth knowing about if you're looking at an amended clause. There's then another case called Gear, where the clause, which I've put on the right of the screen, is quite an amusing one, a very, very messy clause. Hopefully you won't have to look at one that's as messy as this. So it starts off in the usual way where the trade contractor wants to make a claim, and he gets his claim, provided always that he makes his claim within a certain period of time, 2 months in this particular one. And the clause then finishes up by saying it shall be a condition precedent to the trade contractor's entitlement under this clause 4.21.1 that the notice has been given. But unfortunately, clause 4.21.1 didn't actually exist in the particular contract. It was a mistake in the words. So the clause as written made no sense. It says that you'll only get your extension of time under this specific clause if you give a notice, but you didn't get the extension of time under that clause anyway, because it wasn't there. So that was the problem. And the court said, okay, we're not going to worry about the last bit of the clause referring to the wrong contract clause. We're just going to look at the provided always that meaning, and we're going to hold that this is a condition precedent anyway. So the earlier part of the clause was sufficient to establish a condition precedent. And the intention of the parties had been to refer to clause 4.21, where an entitlement did arise, as opposed to 4.21.1, which didn't exist. So that's quite a good example of the court taking a practical approach to what the contract actually means. Another case called Obrascon. This one will be specifically interesting to everyone who wants to know about cases on FIDIC. And of course, there are relatively few cases on the FIDIC standard forms because they're usually used in international projects. and therefore often subject to international arbitration where you don't get a reported judgment. But this is one of the few, in English law at any rate, reported cases on the FIDIC 99 Red Book. We've already looked at the clause, and it was whether this was a condition precedent and what the effect of it was, how it actually worked in practice. So it was conceded that the notice was a condition precedent because of the warning that's been given in the second paragraph of the clause. And the issue in the case was, how shall we construe the trigger? The notice should be given as soon as practicable and not later than 28 days after the contractor became aware or should have become aware of the event or circumstances. So the argument was, when does the 28 days start? When should the contractor have become aware? And what the court said was, notice was only required once there actually was delay of which the contractor was aware, should have been aware. So that's very significant, because everyone will understand, who's listening to this talk, that sometimes things happen on a job and you don't know whether they're going to cause delay or not immediately. They might do, but they might not either. And the event or circumstance was construed very, very broadly to mean either the incident causing delay or the delay which results or will inevitably result from that incident. So it could be either the event or the consequent delay, one of the two. And no particular form was called for, so the clause permitted any claim, provided it was made by notice in writing, and it described the event or circumstance relied on. So you won't be surprised to learn that it was found that the contractor had in fact given notice in Ombruscon on that basis, and the 28 days started much later than 28 days after the actual event had occurred itself. I've put in the golden exquisite on the slides. It's a shipbuilding case, which I won't, I can see I'm running out of time, which I won't spend too much time on, but it's another case where the commercial court emphasised the importance of the receipt of notice to the employer or the buyer so that they were aware of the claims. So it's another, really, from the point of view of this audience, a case that's mostly interesting because it's emphasising why actually the employer wants the notice to be given. Discretion, I have put this in because this is not a standard form clause in FIDIC. You do see it in some other standard forms like logic, and you do sometimes see it as an amendment, because sometimes employers think that this actually increases their rights rather than the reality, which is constrains them. So it's worth knowing, both employer side and contractor side. If you put in a provision in your contract which says there's a notice requirement, a strict notice requirement, but if the contractor fails to comply with it, then the employer has a discretion to allow the claim in any event. What employers I think that means is that they can just decide yes or no. Okay, the contractor hasn't put a notice in, and if I want to, I can give him the claim if it's a small amount of money, or I don't really mind. But if I don't want to, I don't have to. But what English law says about this is that the employer is exercising a discretion whether to grant the claim or not in that situation, and therefore he has to exercise that discretion without being arbitrary or capricious or perverse or irrational by way of an implied term into the contract. And the judge commented that the notice provisions are needed so that the employer has information about the claim in a timely manner so it can assess the claim being made, and that the absence of information given at a particular time might make no difference to what the employer would ever have done. And if that's right, if it would have made no difference because either the employer knew all about it anyway or what the employer did wouldn't have changed, then it would be an abuse for the employer to reject the variation. So in fact, if you see discretion clauses in notice provisions, that is in fact better for the contractor than a straightforward situation where if he doesn't put the notice in, the condition precedent says you can't get the claim. So that's the end of my talk. I will just stop sharing. And I think we might be having a short break.
All right, Lucy, thanks a lot for your session. There are a few questions again for you as well, which I'll drop to you in the open forum time. And I guess now I should just inform the viewers that we're going to take like a very short break of like 5 to 7 minutes. after which we will have Geraldine speak on measurements, valuation, and determination thereof. So I will hope that all the viewers return in about 5 to 7 minutes. And after that, Geraldine, I think you can take over straight away from there.
Brilliant. Thank you. Enjoy your break, everybody.
Thank you. Hi, Geraldine.
Hi, Gracious, ready to start again?
I think so. We can begin. Oh, sorry,
Excellent.
restart rather.
Yeah, part 3. Delighted that you've stuck with this so far, and thank you to the previous speakers, Murali and Lucy. Part 3, we're going to look at measurement and variations. So hopefully you can all see my screen. I have in front of you the header sheet showing measurement and variations. In terms of the slides, in terms of the company I work for, there's a little bit of information there about the driver group. We are a market leader in expert witness, planning, commercial, and as Gracious said earlier, particularly dispute avoidance. We were established in 1978. We are stock exchange listed, and we have a network of offices around the world as well. We've recently published our latest digest magazine, which is available on our website or using the QR codes. So in terms of a very brief introduction to this whole area, of course, construction contracts generally fall into 3 categories. We've got lump sum contracts, where a contractor gives a price for doing all of the work specified. And of course, the contractor is taking a risk that their price is high enough. Secondly, remeasurable contracts. And then finally, target cost contracts as well. By far the most common out of those 3, of course, is lump sum contracts. In terms of FIDIC, then, the remeasure contracts, of course, include the FIDIC Red Book and the FIDIC Red Subcontract. And then for lump sum contracts, we have the FIDIC Yellow, and there is also the option of having the FIDIC Red Book with some amendments. And I would highly recommend that you have a look at the guidance for the preparation of particular conditions, which is part of the FIDIC publications as well, if that's something that you would want to do. So touching first of all on measurement, then under the FIDIC Red Book. Clause 14.1 is where we start with this particular section. Now, I'm not going to look at the whole of 14.1 because, of course, I'm doing payments on session 3 in a few weeks' time. We're just looking, first of all, at 14.1c, where we've got the big blue arrow. And essentially, this particular subclause confirms that any quantities in the bill of quantities are estimated quantities only and are not actual quantities, because of course under the FIDIC Red we're going to have to remeasure the works anyway. So from having a very short and quick look at only a little part of clause 14, we then move across to clause 12. And clause 12.1 sets out the rules and regulations with regard to measurement. Now, I do think that there's a little bit of, I'll say, unrealisticness about this particular clause in the contract, because 12.1 confirms that it is the engineer who is responsible for measurement. And certainly in my experience, actually the organisation who completes the measurement is normally the contractor. If it is the case that it is the contractor who is going to remeasure the works, then actually we would recommend that clause 12.1 is amended to reflect what is actually going to happen. 12.1, unfortunately, is a bit of a long clause. So it starts by saying that the works are going to be measured and valued for payment in accordance with clause 12. If the engineer wants any part of the work measured, then the engineer has to give notice to the contractor's representative. The contractor's representative must then attend and provide any particulars to the engineer. Now, importantly, the last part of the clause on this slide, if the contractor fails to attend or send a representative, the measurement made by or on behalf of the engineer is then accepted as accurate. So it is definitely in the contractor's best interests to attend that measurement. But again, remember, if it's the contractor that's going to fulfill the measurement role, then of course you will have to amend the clause for that. Now, I did say this is a particularly long clause. It goes on to say and look at the situation where works are going to be measured from records. So the clause says, except as otherwise stated in the contract, wherever any permanent works are to be measured from records, these shall be prepared by the engineer. The contractor shall, as and when requested, attend to examine and agree the records with the engineer and shall sign the same when agreed. If the contractor does not attend, exactly as we saw before, the records shall be accepted as accurate. So it's important to recognise that this is all driven by the engineer, and the contractor then attends this particular exercise. The final section in relation to clause 20.1 looks at what happens if the contractor doesn't agree with these records. So if the contractor examines and disagrees with the records or doesn't sign them as agreed, the contractor shall give notice to the engineer as to effectively why the contractor considers that the records are inaccurate. Remember back to Lucy's session earlier on, she emphasised the importance of making sure you give the notices in accordance with the contract, and this clause is no exception at all. If the contractor does disagree, does issue the notice, the engineer has an obligation to review the records, confirm the engineer's view, or to vary them in accordance with the contractor's view. Finally, if the contractor doesn't give such a notice within a 14-day period after being requested, they are accepted as accurate. So again, you can see from all three parts of this clause, the onus is on the engineer to perform the initial role. The contractor essentially has a checking role, but is under a time constraint if the contractor is not in agreement with what has been recorded. If there's no notice given within those 14 days, the engineer's measurement stands. Okay, moving on to clause 12.2. This is a shorter clause and says, except as otherwise stated in the contract and notwithstanding local practice, item A, measurement shall be made of the net actual quantity of each item of the permanent works, and method of measurement shall be in accordance with the bills of quantities or other applicable schedules. Now, there's a number of points to make here. It uses the word net, and of course we all know it's nothing to do with fishing. I worked recently with a dredging contractor, and we had great discussions on the word net, how it fitted in with the issue of over dredging, where you have to dredge more to make sure that the channel on the seabed is of the sufficient width that's required or depth that's required, or indeed in relation to bulking factors, or finally in relation to siltation. So this clause definitely needs further thought in relation to how the method of measurement is going to work, how that fits in with quantities. In relation to item B and reference to the method of measurement, my background is working in building in the UK, and certainly I would be very used to using a particular rule book in relation to how you measure items in there. Here, actually, there's no reference to a rule book, and again, I would want contractors, engineers and employers to understand how the works are going to be measured to avoid any particular disputes. We then move across to clause 12.3, which states, except as otherwise stated in the contract, the engineer shall proceed in accordance with subclause 3.5 determinations to agree or determine the contract price by evaluating each item of work, applying the measurement agreed or determined in the previous clauses and the appropriate rate. So we've covered so far how you actually complete the measurement, and we're moving on now to look at the rates. The second part of clause 2.3 says, for each item of work, the appropriate rate or price for the item shall be the rate specified for such item in the contract. So that's very straightforward. Essentially, that's the use the rate rule, or if there's no such item, specified for similar work. So essentially, if the work scope doesn't change, the rules are straightforward. We're going to use the rates in the contract or rates for similar work. The difficulty comes, of course, if the rates aren't appropriate. But again, FIDIC kicks in and tells us what to do in this clause 12.3. It gives us two areas as to how and when a new rate is going to be used. There's clause 12.3a, and you can see written on the screen there that there are 4 criteria as to when a new rate or price is to be used. So for example, item 1 is where the measured quantity of the item is changed by more than 10% from the quantity of this item in the bill of quantities or other schedule. And there's 3 other possibilities as well. Now, the important thing I want to point out here, and hopefully you will actually see my mouse on the screen, at the end of subclause Roman numeral 3, it uses the word and. So in other words, you can only use a new rate or price if you come within all 4 criteria of subclause 12.3a. Now, there is another option. Of course, we have clause 12.3b, and there's 3 criteria here. And again, you will see reference to the word and. So when can you use a new rate? If you come within the criteria, and I will just flick back, you come within the criteria of 12.3a, and it must be all 4 criteria, or indeed, you come within the criteria of 12.3b, and again, you need to meet all 3 criteria there. 12.3 continues and explains how you come up with a new rate or price. And essentially, you are looking at adjusting the old rates, taking account of reasonable cost. And you can see here that the word cost has got a capital letter, so it's a defined term. And you also take account of a reasonable profit. Now, this is where it is definitely good to have a QS working with you, because everybody has a very different idea of what the word reasonable means, both reasonable cost and also reasonable profit as well. Just looking at the definition of cost, under the red and the yellow books, cost is defined as the following. It means all expenditure reasonably incurred or to be incurred by the contractor, whether on or off the site, including overhead and similar charges, but does not include profit. Now, of course, I'll just flick back again. We can see 12.3 confirms that the contractor is indeed entitled to profit in relation to this particular item. Again, I would advise, based on experiences of having brilliant arguments with people about what a level of reasonable profit is, that is certainly something that could be pre-agreed by the parties as part of the tender negotiations, and also written into the contract as well. So we've covered there the issues in relation to measurement. The last sections of my talk relate to the valuation of variations. FIDIC red is a little bit more complicated here than FIDIC yellow. We have a definition of a variation at clause 1169, which is essentially any change to the works instructed or approved as a variation under clause 13. And of course, we need to flick across to clause 13. It emphasizes the role here of the engineer. So variations may be initiated by the engineer at any time prior to the issue of the taking over certificate for the works by an instruction or a contractor's request to submit a proposal. There is no mention of the employer initiating or the contractor initiating here at all. The Red Book does give some excellent examples of variations. The first few items are what I would describe as run-of-the-mill examples. So changes to the quantities of the item, the quality of the work, to the levels, etc. The one I would want to highlight, and certainly from a contractor or subcontractor's perspective, the one that actually is missed out quite often, a variation includes changes to the sequence or the timing of the execution of the works. So we now know, hopefully, what a variation is. How do we go about valuing variations? Well, again, we are looking at clause 13.3, and we're also back to clause 12.3 as well. And we're looking at the rules in relation to the contract. Essentially, if the work is similar in character and conditions to the existing work, you use the rules in the contract. If it's similar in character or conditions, the starting point is the rate in the contract, but you're then going to tweak the rate up or potentially down. Rule 3 is used where the work is not similar in character or conditions, and essentially then you're going to look at a fair valuation. Now, I will just give you the same health warning as Lucy gave before, and this is a UK case, and equally it's not on FIDIC, but I would say that the outcome of this case is transferable across into FIDIC. Again, you'd have to look further in relation to Indian law or the particular jurisdiction that you're working under. This case is also worth a read if you get the time. Quite simply, Henry Boot had included in its contract for some sheet piling works, and post-contract instructions were given for more sheet piling works. Luckily enough, Henry Boot had a very, very advantageous rate for the sheet piling. And when the employer instructed more sheet piling, understandably, Henry Boot wanted to use the high rate for the additional sheet piling. And effectively, it was going to achieve then windfall profits. The employer, in this case, Alstom, did not want to use that, in their view, ridiculously high rate. And they thought instead that the contract rate should be disregarded and a fair valuation used instead. Well, this case actually went to the Court of Appeal, and it was held that the rates in the contract are sacrosanct and Boot benefited. And essentially, it didn't matter whether the rate was very high or very low. If the works were of a similar character and executed under similar conditions, the contract is clear that the rate in the contract had to be used. So this resulted in a very happy contractor in this particular case, but of course only because their contract rate was actually very high. Moving towards the end of the presentation, we have a couple of notes in relation to valuation of variations under the Yellow Book. And of course, if we are using the Yellow Book, we are expecting that there are different documents that form the contract. So the definition of a variation under the Yellow Book is slightly different. Here, it is not just any change to the works, but any change to the employer's requirements or the works instructed or approved as a variation under clause 13. Again, we have a look at clause 13 in the Yellow Book, and it is very, very similar to what we read earlier in the Red Book. Variations may be initiated by the engineer at any time prior to the taking over certificate for the works. There are some wider exceptions as to when a contractor can potentially give notice to say that it may not be able to do these works, but I'd say that these are rarely used. We move on then to look at the variation procedure and the evaluation. And actually, I do quite like the way that variations are looked at under the Red Book, because there is a degree of clarity in using the 3 rules, as we saw through the Henry Boot case. We haven't got that under the Yellow Book. Quite simply, the contract says that the engineer shall proceed in accordance with subclause 3.5 to agree or determine adjustments to the contract price and the schedule of payments. The adjustments shall take account of reasonable profit and the contractor's submissions. So essentially, we don't have the rules there at all. Now, throughout my presentation, I have mentioned quite a few times subclause 3.5, the determinations clause. And so I'm going to end my part of the presentation today looking at determination under the Red and the Yellow Book and this clause 3.5. The clause itself says this, and it is worth spending a couple of minutes on it. It says, whenever these conditions provide that the engineer shall proceed in accordance with this subclause 3.5 to agree or determine any manner, the engineer shall consult with each party in an endeavour to reach agreement. Well, that's all very sensible. The parties to the contract, the contractor, the employer, the engineer consults with them and they try to seek agreement. Great. It goes on. If agreement is not achieved, the engineer shall make a fair determination in accordance with the contract, taking due regard of all relevant circumstances. Now, I appreciate today we've got a mixed audience, not just in relation to the speakers, but those who are listening into the session and also those people who will listen in and watch us on YouTube afterwards. I am sure that employers, employer representatives, contractors, and engineers will all have a very different view on what the phrase "a fair determination" actually means. And of course, in this particular clause, the engineer has got to wear an independent or impartial hat when carrying out their duties. Of course, if they decide a figure that's too low, this could end up meaning that the contractor takes a case against the employer for extra monies. Equally, if the figure is too high, the employer is not going to be best pleased either. So we're looking for a figure that is just right in relation to determinations. And that is no mean feat from the appointed engineer to the contract. That actually concludes my part of the presentation for today and concludes the 3 speakers. So it is with a degree of nervousness I invite Gracious back onto the session. And I'm certainly hoping that there are very difficult questions for Murali and Lucy and no questions from me at all. I'm keeping my fingers crossed at this point.
Well, I was thinking of starting with you since it's all fresh.
No.
So, yeah, I'm glad that the others have also joined. I'm not sure why my webcam's not working. Sort of gave up in the middle. But anyway, Geraldine, you mentioned regarding the engineer's role in measurement. And I was wondering why you think that is the case in FIDIC forms, that the engineer is expected to do the measurement. And is it the case that there is some sort of a presumption that the contractor might like take advantage of the fact of doing the measurements and the engineer not being able to validate it? So in a remeasurement contract, does it actually make sense for the engineer himself to do it for the employer's sake?
Well, certainly from my perspective, I just don't think it makes sense. The dredging company that I was working with last week, I made the point, I just could not imagine the engineer to the contract putting on their diving suit and taking their tape measure and swimming along the seabed to make these measurements. It just wouldn't be realistic, particularly when dredging companies, of course, have very sophisticated computers on their survey boats, and all of that then effectively is done via computer reading. And what happens in that particular case, the engineer would probably have great discussions with the contractor, making sure that the instrumentation was calibrated, making sure that everything was in place, and might actually do some spot checks in relation to the works using the contractor's equipment. I think this is a historical hangover, essentially. If I go back years and years and years and years and years, where the engineer would take a far greater role in the project. The FIDIC contract that we've concentrated on mainly for today has been the 1999 contract. Well, actually, that's now heading towards 20 plus years old. But even 20 years ago, the engineer probably wouldn't have donned their diving outfit at all. I just, in my experience, I just don't think it's realistic. And I think that particular clause needs to be looked at, and it needs to reflect the actuality myself. So yeah, I think it's a historical nicety, effectively.
Understood.
Gracious. Yeah.
Well, that's a nice suggestion, by the way, in terms of like the amendment that could be considered, or at least a suggested clause as part of the FIDIC conditions that could also be considered by FIDIC. Another related question now, that since you do mention dredging contracts, and I do understand the complexity that involves in measuring the work that was done. Let's say there is a disagreement between the contractor and the engineer regarding the measurement. I suppose he's left with a couple of options. One, he disagrees, and I mean, what's the logical end to this? One, and secondly, if he agrees but protests the measurement, and then what's the logical end to that, to those circumstances?
Sure. So if the contractor is not happy with the engineer's measurements, so we'll go down the theoretical route essentially on the contract. The engineer then would be invited to do a formal determination under the contract, and effectively would have to lay out their reasoned decision and all their measurements as well. And if the contractor still isn't happy, then of course you would hit clause 20 and you would look through the dispute resolution clause. I think, again, thinking about the reality of it, I quite like the phrase shelf stacking at this point. And I don't think that for a dispute on one measurement item, the parties would be instantly going to clause 20 and down the dispute resolution avenue. Instead, they would probably stack the disputes up. And then if the disputes reached a particular figure, then they would look at going down whether it's the dispute avoidance board, or they'd go to arbitration when they're of a sufficient figure. Equally, the parties might still disagree, but actually they might have a number of other disputes, and there might be an overall settlement over 4 or 5 issues that might involve measurements or variations. I cannot recall, certainly in the cases that I've been involved in, where it's actually gone to arbitration, litigation, adjudication in relation to a measurement issue on its own. The parties may take, I'm going to say, a slightly off beam and away from the contract approach, and they might just actually get an independent third party in to have a look at this issue to see if that will kind of force the parties down a more sensible route in relation to measurement items.
And where does he do the stacking? Is it in the IPAs that he keeps referring them as unclaimed?
So for me, when you have an issue that hasn't been agreed, let's say that the first issue is worth, let's say $50,000, and then the next issue is worth $25,000, it wouldn't be worth going through the adjudication or arbitration or litigation process on that item on its own. So essentially the issues are stacked till they reach a critical mass, essentially. So it is worth going, or it's dealt with on the account as a whole.
Understood.
Okay.
All right. Murali, there are a few, actually your session had quite a few questions coming your way. And of course, program is one of the most, hotly contested issues between the contractor and the employer / engineer. And I was wondering, I want to start right at the beginning. Of course, the engineer or the employer is expected to give a 7-day notice before the commencement date. But what generally should a contractor be doing just to prepare in the 42 days that are available to him from the letter of acceptance up to the commencement date? Is there some kind of preparatory expectations that a contractor is obliged to do, or does he actually start, functioning right when he gets that notice of commencement?
Right. When it comes to the contract becoming effective, it happens during the acceptance of letter of tender by the employer. So the contract is actually effective. It's just completion. The completion date is the start. You recognize the start of the project, but otherwise the contract is effective, and a lot of background activities are being carried out by a contractor. Like, for example, you want to fix up some contractors for temporary works. You want to install some of these temporary facilities. So you need to negotiate and fix up the contracts with some of the subcontractors. Once the site is handed over, you need to do that. And I think this is the time which the contractor can utilize, and also apply for the bank guarantees so that the performance security is available by the time the site is the employer hands over the site.
Right. And then moving on to the issue of DTPs itself, there have been quite a few instances that I've come across where a DTP is obviously illogical, yet the contractor has made that submission. And with that illogical...
By DTP?
An illogical DTP. A time program that is obviously doesn't make any sense, logically speaking.
Okay.
But yet the engineer doesn't really, show it and put out any red flags to it, and it's sort of, it's impliedly approved. But later on, there is always an issue as to the use of this particular time program. I mean, how do you think this plays out? Because I feel the employer, if the time program was at the disadvantage to the contractor, the employer always wants to take advantage of it. And if it was in the in the disadvantage to the employer, then the contractor sort of takes advantage of it. So how do you sort of reconcile this kind of a problem between the contractor and the employer concerning the time program itself?
Okay. Once there is this baseline that is set, that is, the employer may not approve it explicitly, but again, the contractor is expected to proceed with the baseline in case the employer doesn't raise any comments regarding the non-compliance with the contract. So once this contract is, once the project progresses, you need not actually wait till the till the problem occurs, but right after the project progresses, the problems are quite visible with respect to program, because when you start updating the program, there are issues. So and that's the starting point of the discussion and debate that happens between the employer and the contractor. And many times during these discussions, there are some corrections, if applicable, that are made and agreed between the parties. And later, in whatever I have seen, at least in 2 projects where there was a part of the delay analysis meeting, is that this issue is always there, and in some cases you have illogical float or illogical float that appears in the schedule just because you're not tied up certain activities properly or things like that. And in certain cases you have a delay event that is being recorded, but when you are putting it into the schedule, it's actually not fitting well into the schedule, and it creates a kind of a disturbance in the schedule. In all such cases, it is up to the parties how they discuss this issue and settle it amongst them with respect to the time impact. And I don't see that there is a very written down solution for this problem, because most of the cases, this time extension, at least in India, it is agreed on the basis of mutual discussions. So this problem is there, and I don't have a solution for that as such.
Okay. Except for party cooperation, I would think.
That's it.
Lucy, there was something that Dr. Murali mentioned, and I thought it was interesting. I wanted to ask you this. Murali clearly made this distinction of the requirement or the obligation for advance warning, while that exists for the contractor in the 19 edition. But the 2017 brings that for the employer as well. Well, let's say we are operating under the 19 edition. Do you think that this obligation for advance warning can arise out of a different source than the contract? Let's say under the obligation of good faith. Well, if the employer does have in his knowledge, something very, very serious that's going to occur, but does not share that with the contractor, do you think this kind of an obligation may arise in a different way for the for those projects that are operating under 19 edition?
The 99 edition.
Right.
I'm not sure. I'm not sure that it does, because, and the reason I say that is because if something has gone wrong, which is on the employer's side, an employer risk event, the contractor has a remedy for that already. So whether or not the employer gives an advance warning of it, I mean, it might be sensible for the employer to give an advance warning if he knows that there's a problem, and that might enable everybody to work together to overcome the worst impacts of whatever the problem was. But if he doesn't, and the thing that happens, like a problem with access, which is a sort of typical one that you might get early doors.
Yeah, imagine there's a protest that's going to happen soon, and the employer is aware of it.
No, exactly. So that would be an employer risk event, I would have thought, under FIDIC normally. You're looking at, if it prevented access, doesn't really matter what the cause is. You just haven't got access, so that's an employer risk thing, because the employer's got to give contractor access come what may. Then the contractor's got a claim. So I don't think there would be any need to read in an additional obligation on the part of the employer to give the advance notice, because there wouldn't be a missing remedy for the contractor. He would just have claim for time and money because he hadn't been given access when he was supposed to, whatever the reason was. Now, that obviously, I mean, as I say, I think commercially, it would be very sensible for any employer who knew there was going to be a problem to use the advance warning mechanism to raise that and get a discussion going on it, because maybe there's a different way of getting access. Maybe the contractor can come the day before, get his cranes on site the day before, whatever it might be. There might be a very, very straightforward way, actually, of dealing with whatever the problem is, which you won't be able to work out unless you ask. And it might cost the employer a little bit more to make those amendments if they're different to how the contractor was originally planning to carry out the works, but that might be infinitely preferable than just having what potentially would be days or longer of delay,
right,
that he would be paying for anyway.
Murali, you have any footnotes to add to that answer?
No, I think I pretty much agree with Lucy on this.
Right. Yeah. Great. Lucy, I have a follow-up question again on the law aspect. I understand, yes, that under English law, that the idea of a condition precedent is pretty much the norm in terms of 20.1 related issue. As far as the Indian law is concerned, and I'm sure that you may have heard of this, that 20.1 as such is considered, at least the notice requirement, is considered to be unenforceable in law. because
it's very common in civil law, where in jurisdictions that have some civil law elements, that there's rules that override those provisions.
Right. And the rationale that the Indian law provides is that where there's a certain notice requirement that shortens the limitation period available to raise that particular claim, there is these sort of clauses are considered to extinguish the right of the contractor. And I don't think, and Murali, maybe you can correct me if I'm wrong, I doubt that any of the Indian judgments have actually discussed the condition precedent aspect of it. Normally people do end up directly jumping onto the enforceability part. But
it's very, very interesting, because in English law, it wouldn't be regarded as a limitation issue at all.
Right.
Because obviously we have similar provisions as you guys do in relation to the overall time that you've got as a matter of statute to bring your claim in, and the sort of condition precedent type way, and the mechanisms within the contracts. That's what the parties have agreed as to when they're going to bring their claims under the contract, are not regarded as equivalent to limitation. They sort of come before it. So I don't, if you haven't had a case yet that's discussing the FIDIC wording, and we also suffer in the UK from FIDIC not coming before the court sufficiently often for us to get enough guidance on it, then that will be very, I think I would have thought it'd be an interesting debate.
Yes. So this next question is actually something that perhaps both Lucy and Geraldine can sort of give their thoughts on. Let's say even if the engineer, truly believes that a certain event is not a variation, right? Is the engineer nonetheless required to issue instructions? I mean, how does that play out for the engineer versus the contractor?
He just has to give instructions if he wants a thing to be done. An instruction doesn't equal a variation. An instruction is just do this thing, Mr. Contractor, and it either is or isn't a variation compared to the actual scope of work as defined in the contract. So there's nothing for an employer, if he's confident that he wants the contractor to do a thing and doesn't think it's a change, he should definitely issue the instruction, because it makes no difference. He hasn't exposed himself to any risk at all. And if it is properly construed a variation, then it's not going to help him at all if he wanted it done but was havering around, refusing to say I want it done, and probably causing some delay by faffing around. So there's no just issuing instruction itself doesn't change the allocation of risk under the contract at all.
Geraldine, any thoughts on that?
Either that instruction either is or isn't a variation, objectively speaking.
Either it constitutes to be a variation or it does not.
Yeah. Otherwise, it's just an instruction that the contractor has to follow. And that's why, and I think that question, I think, is one of the reasons why there's often confusion on site, where contractors are saying, I think it's a variation, I don't have to comply with it, but that's not what the contracts say. The contracts say, there's an instruction, you've got to go off and do it, and basically argue later, effectively, put your claims in and argue later. But the issue of instruction per se doesn't make it that the employer is admitting that it's a change. And you quite often see on jobs, I'm sure Murali and Geraldine have both seen this many times, where you'll get a formal instruction with the employer having written on it, or the engineer having written on it, this isn't a change. And that just that makes no difference whatsoever. It either is or it's not. The issuing of the instruction, it doesn't change the allocation of risk, neither does writing on it, this is not change.
Just to add to that, those kinds of issues quite often arise because of very poor contract drafting in the first place. So if I give a very silly example, that part of the contract says that the contractor must paint the walls green, and then decides actually he wants a specific shade of green or wants luminous paint, well, it's still green paint. If he then gives an instruction to say, no, I actually want mint green or luminous green or sage green, that's a change to the contract. Is it a special paint or not? Who knows? You'd have to then dig into the document itself. But I would absolutely back up what Lucy said. It's not about the instruction itself. Whilst most contractors would hear the ringing of cash registers in their ears as the instruction comes across, you have to go back to the contract and see what it says about the colour of the paint or whatever, and decide, is that a variation that then attracts money or not? The piece of paper with the word instruction on isn't the item that leads to money. It's whether it's a change against the original.
Right.
I'm
And
just
speaking
going
of,
to add one point.
go ahead.
Sorry.
Yeah. Go ahead.
In fact, if you look at the FIDIC Silver Book, it even says that employer may issue instruction for the contractor to perform the obligations under the contract. Now, it's an instruction to perform the obligations under the contract, so it doesn't change the risk allocation. Is what I understand from that line. Yeah.
Right. Now, since we are on variation, I mean, I was thinking, a typical situation where a certain work hasn't really gone through the variation procedure, the 13.3. And it's often the case that, the contractor doesn't want to wait, or, doesn't find it prudent to wait for a formal variation instruction and goes ahead to complete the work in the interest of the project, right? And this, more often than not, employers very mischievously want to take advantage of this fact that there was no variation instruction that was given, and that the contractor volitionally has actually performed the work, and making the argument that, well, those works were necessary for the purposes of completing the work, and therefore there was no variation at all. And that puts the contractor in a lot of predicament. I mean, because now he has to go through a lot of thresholds to prove his point that this was indeed a variation instruction. How do you sort of reconcile, or how do you understand the situation from the contractor's point of view, of course?
If I just roll back a few minutes there, Gracious, I often joke that contractors, when they become a contractor, they've got the words, it's about getting the job built tattooed on their eyelids, rather than thinking more widely about, I've been employed to do what the contract says, and I'm here to make money. So they look at what's the outturn on the project, rather than actually thinking about their own commercial interests. So the first point I would definitely make is the contractor absolutely should wait for that formal instruction to come, and that makes things far easier, and then I wouldn't have to answer your more difficult question, Gracious. But then if the contractor does go ahead with the work, it's just a form of gambling, essentially, in relation to, is that something that the contractor will get paid for or not? Because if the engineer hasn't given that formal go ahead on, going back to my example, the colour of the paint, or it could be the amount of reinforcement, or the nature of the specification of the concrete, and the contractor is saying, well, we had to use the higher strength concrete or the extra rebar in this situation, and it is a variation. Well, actually, that's going to come down to effectively expert evidence if it goes all the way, and it can't be decided at site level, essentially. And I think maybe I'm probably a little bit biased, having worked for contractors in the past. Yes, I agree. You've made the points that do employers maybe take advantage of this? I think, yes, they do, but contractors allow them to take advantage. The contractors should be saying, I need this instruction from you. And I think that contractors often are a little bit too helpful in this situation, and I would like to rein them back, unfortunately.
Do the others have some thoughts on this?
I mean, it's much better commercially, contractually, to make sure you've got the instruction and you're not helpfully running around doing things before it's been recorded. At the very, very, very least, I think contractors should be sending an email to the employer saying, we understand this is what you want. This is what we're planning to do. Please let us know if this is the wrong thing. Because what you really want to do is just clarify what's being asked. You want to get into writing at the time what's going on and what you're being asked to do, so that it's very difficult later on for the other side to argue about it. And as Geraldine was saying, the debate is often the contractor saying, give me instruction, give me instruction, give me instruction, meaning admit you're instructing a change. And the contractor and the employer says, it's not a change, it's not a change, it's not a change. The debate's all wrong. It either is a change or it isn't. And you know, obviously under some forms of contract, the employer can issue instructions that expressly accept that they're a change. They'll state on them, issued under this clause, which is a change clause, or they could just give a normal instruction. So, okay, I mean, sometimes you know it's just undisputed that it's a change right from the very, very beginning. But if there is a dispute, then what's most important, as Geraldine says, from both sides' perspective, really, is that what's going to actually be done is clear, at least that bit sorted out, so that then when you have the fight later out whether it was or wasn't a change, you know what you're talking about.
Right. I'm tempted to sort of continue with the variation theme.
That's mean,
and
gracious. Come on.
And I tell you something else. Another point that occurs to me, gracious, is that the other reason for a contractor to be very clear about all this stuff is that it gives him a timetable for his notices. Right. And it puts the contractor in charge of when he's going to be giving his notices, which, whatever the law might be, is better if you give them.
Correct.
Because you signed up to a contract that says you're supposed to. So don't take the risk. Don't take the risk of not doing it.
Right. So just continuing with the variation and being mean about this, you know, what I was hoping to sort of understand, what is exactly the scope of this variation instruction that, you know, an employer can give? Does it mean that the employer can, obviously it doesn't mean that the employer can give anything and everything under the sun as a variation instruction and say that you've got to build this. And, you know, I've also seen situations where the employer is actually departing from the original scope of the work to sort of give something which is different in character and suggesting that, no, this is required for the purposes of the project. And on those occasions, you know, the contractor finds himself in a very difficult position to deny such a variation instruction. So, you know, is there some sort of an understanding of, you know, what kind of things can be given as a varied instruction as such? What kind of work items can be issued as a variation work?
Sure. So there's a limited number of cases where the courts have looked at a particular variation and said what's been instructed is absolutely outside the original scope. Now, I can think of two examples where that was where that actually occurred. One, we're back on my dredging contractor type scenario.
I think I have come across this one.
This is a fantastic case.
Yeah.
So the contractor there was down to do dredging, and the contract was very clear that the scope of works was to dredge part of this particular area. And it's a few years ago, the case, but obviously the employer had their own environmental credentials that they wanted to show off. So partway through the job, they decided that the dredged arisings should be used to create a bird island. Now, it does seem as if they're using the dredged materials. Is that within the original contract, or was it a completely different contract? Now, from the contractor's point of view, they considered that they would get a lot more money if they were able to say it was a separate contract, whereas the employer thought that they would have to pay a lot less if it was under the original contract. Now, the court decided in that particular case, and again, I'll give you the warning, this is another case that was under English law. So again, we might have differences with India and other jurisdictions. The court decided that that was outside the original scope and it didn't fall within the original scope of the works because it was just so different in nature. So for me, if I'm looking at this and following that particular case, it has to be something that's absolutely outside. And thank you very much. You've put the case name there. Blue Circle Industries and Holland Dredging is that particular case on the Bird Island. Now, there are many, many other examples where contractors have tried exactly the same argument and they've failed. There was a case, from memory, it involved a particular construction of an offshore, what would I say? It was an offshore building, and there were literally hundreds, if not thousands, of changes to the works. And the contractor claimed, it's just too much. The changes cannot possibly come within the original scope of the work. There are too many of them. And the court said, well, actually, we agree that there are lots and lots of changes. We agree that there's been many, many drawings that have been issued, but it all comes within the original ambit of the first contract. Just because you've got lots of change doesn't form an entirely separate contract at all. So going back to your question, Gracious, it's going to be an exceptional situation where a variation instruction is given that is outside the original scope. The Bird Island example is one of the very few cases where the courts agreed that it was an entirely separate contract.
Right. And now I want to actually mix up variation with a bit of delay. I mean, Murali, you did make a remark regarding, issuing of a variation order during the delayed period. Where the contractor is delaying and the employer is entitled to levy liquidated damages.
Right.
And it is around the same time that the variation gets introduced.
Right.
And at that point, you suggested that, well, the employer will still be entitled to levy the liquidated damages. I thought that it's such a mischievous action on the part of the employer to take advantage of the contractor's delay at that point and issue a variation instruction, in the sense to sort of hide the delay that comes out because of the variation per se. Any thoughts on this particular issue? I mean, I thought it's employer can be really mischievous with this particular tool in his hands.
While I personally agree with you, but looking at the way the FIDIC contract is drafted, I feel this is something that the employer enjoys. This particular what to say, a benefit or whatever you want to call it. Actually, because see, the fact that the contractor is subjected to liquidated damages only means that still the time is not at large, right? And when time is not at large, it's that the contractor is it's still okay for the employer to issue a variation, and it doesn't affect anything in terms of contract becoming the time becoming at large. So the worry is that if time becomes at large, because the argument here is that by issuing a variation in the extended period when already the contractor is subjected to liquidated damages, whether it becomes time at large, and the answer is no. So under that circumstance is something that the employer enjoys, is what I understand from FIDIC.
Understood. Anybody else wants to?
Time is only put at large if there's no applicable extension of time mechanism in the contract. So if you issue a variation, there's definitely an applicable extension of time mechanism. And the question is, what additional delay did that variation cause at the time it was issued? Yeah, that's all. If it has caused an additional delay, sorry, Murali.
Yeah, so if it has caused an additional delay, then yes, that is to the extent to that the employer is responsible. But if that has not caused an additional delay and it goes within that extended period, then I think the employer still enjoys that benefit of issuing a variation instruction without affecting this entitlement for liquidated damages.
I totally agree that's definitely the law in England. There's a good case discussing that situation called Adyard and SDMS from 2011 in the UK. It's a first instance case, but it has an example in it. It's a case that I was in, that's why I know the title of it off by heart. But it has a good example in it about a situation where a contractor is obliged to paint a wall and the employer wants to change the colour of the paint. And the new paint's going to have a long lead time of 6 weeks to get, but the contractor wouldn't be getting round to painting the wall for another 12 weeks. So in that situation, the long lead time of the paint, the variation, it just made no difference. Made no difference to the progress of the works. It didn't stop the contractor from doing anything. It didn't actually hold him up. And I think with delay points, that the absolute lodestar of the issue, the single thing that you need to hang on to work out what your prospects of success are on either side are, did the thing that happened actually cause the contractor a problem on the site? Was he prevented from doing something, or did it take him longer because of that thing that happened, or was he just getting on with the rest of the job?
I have like one final question, so after that we can wrap it up. There was a certain comment from in Murali's presentation. There was the suggestion that that FIDIC as such does not require the identification of a critical path in your time program. But I've often seen that the engineers find that as a good reason to say revise and resubmit, and identify the critical path per se. What do you think about this as such? Should there be actually a requirement? Should there be an introduction to the FIDIC forms where such a requirement should be placed, or is that not a requirement at all? I see that Lucy is definitely no.
I mean, if we're going to get dragged into critical paths on programs, I mean, what a nightmare! It's bad enough when there's a dispute. I have no faith at all, none, in what the program, an electronic program, shows the critical path to be. It is, at best, it is a piece of evidence. Programs are just not very good pictures of what the real world is. They never have all the right links in. They're never an accurate picture of what the real constraints are. Quite often they've got either ambitious time estimates in, or there's something else wrong with them. I get all of my clients to explain to me in words what the critical path was. I don't think that the disputes will be reduced on. I mean, there are loads of contracts that say you've got to have a Primavera or similar program produced as your baseline program that we're going to agree, and it's got to have a critical path in it, and so on. There are loads that say that. Doesn't make any difference to disputes, doesn't restrict the scope of them. In fact, in my experience, everyone starts arguing about logic links and fragnets and other things that I never want to hear again, ever, until I die. It just leads to more arguments about things that are not actually about what happened on the job. And if you are right about the critical path being where you say it is, you'll be able to explain that you couldn't pour the foundations until the hole had been dug, or you couldn't put the roof on until the walls were there, and it will be common sense. Anyone can understand it. Electronic programs are one of those things that the construction industry thinks are going to be a panacea and solve the really difficult, expensive, time-consuming issue of delay-related disputes on construction projects, and they just don't do it. They don't do it.
Right. Final comments from Murali and Geraldine on the same issue.
Okay, so on the program side from me, I think some very clever person once said to me, at some point everything becomes critical because the works aren't finished until everything is done. I think that's one very important point. And another point is that the critical path can change on a job, not just monthly, but weekly, daily and hourly, depending on the nature of the workforce you've got on the particular project. So if I think of a program, that's just one person's view, and it's one snapshot in time. And almost as soon as the person presses print, actually it's out of date, because some of the people on the site have worked faster, some of the people have worked slower, and there's been a few instructions that have come in. So interestingly, JCT in England does have a possibility of, do you want critical path shown or not on some of their contracts? It's not something that I would particularly get excited about or not. I think if anyone is producing a program, then I think it probably would be more common that they would put the critical path in. But I would describe it potentially as a bit of a false friend and maybe a red herring because of the nature of how construction projects progress anyway. So definitely 100% with Lucy's comments on that.
Yeah, I agree with these comments as well, because if say, for example, it's inserted in the contract clause that a critical path is required to be shown, then there'll be a whole lot of other things that would be coming up, and there's virtually no end to these requirements. And even if you give a page full of instruction on how to schedule it, and I think there'll be another 2 pages full of arguments on the problems with the schedule. So I don't think there is any end to this, and can be left as it is, whatever that's
so
there.
where the engineer has gone ahead to make a comment on the time program submission, saying that, well, the critical path is not really clear, or that there's no critical path. In that occasion, the engineer would be wrong to make such a comment and ask the contractor to revise and resubmit.
Seems so, because whatever the engineer is supposed to comment is whether the schedule is meeting the obligations of the contract, and if the contract is not emphasized on that, then I don't think the engineer can reject the schedule or ask the contractor to resubmit the schedule based on that single reason.
Mm-hmm. All right, speakers, thank you. We are at 8:59 Indian time, which is perfect. We've done a great job in sticking to time, and no delays over here. And I want to once again thank Geraldine, Murali, and Lucy for giving their time and for contributing to this particular session. For those who are viewing this, we will have session 3, and we will see Dr. Murali and Geraldine again, along with David Thomas from Keating. So I guess it's a goodbye to Lucy for now, and I'll see you both in the next session, which is on the 21st of April. There's been a date change from April 28th to April 21st. So I guess I will see all of you later, and thanks again for joining, and appreciate it. Hopefully my voice is better in the next session. All right, guys.
Thank you very much.